I'm Andremi Ortega and I will be presenting the digest case of St. Mary Academy of Dipolog City versus Teresita Palacio, Marijan Calibad, Leve Lacao, Elaine Marie Santander, Eliza Saeli, and Maria Dolores Monte de Ramos, GR number 164913, promulgated on September 8, 2010. In the date of 90s, petitioner hired respondents Calibod, Lacao, Santander, Saeli, and Monte de Ramos as classroom teachers, and respondents Palacio as guidance counselor. However, petitioner informed them that the reapplication for school year 2000 and 2001 could not be accepted because they failed to pass the licensure examination for teachers. According to petitioner, as non-board passers, respondents could not continue practicing their teaching profession pursuant to the Department of Education, Culture, and Sports Memorandum Number 10 Series of 1998, which requires as professional teachers pursuant to Section 278 of the Professionalization Act of 1994. Respondents filed a complaint contesting their termination as highly irregular and premature. They also argued that the security of tenure could not simply be trampled upon for their failure to register with the Profession Regulation Commission or to pass the LET prior of the deadline set by the Republic Act 7836. Lastly, the acceptance of the petitioner of other teachers who do not possess the required eligibility under the memorandum showed evident bad faith. LA adjudged the petitioner guilty of illegal dismissal. Thus, petitioner was ordered to reinstate the respondents or to pay them separation pay at the rate of 1/2 month wage for every year of service, plus limited back wages. The NLRC upheld LA's decision, stating that the grounds relied upon by the petitioner or dismissed the respondents
are not among those enumerated by Labor Code,
and that the respondents are regular employees who cannot be removed without just cause. Court of Appeals agreed with the findings both of LA and NLRC that the dismissal was effected prematurely in violation of existing laws. A contingency plan, according to the Court of Appeals, should have instead been adopted by the petitioner in the event of respondent's termination from the service. Court of Appeals also observed that the petitioner ulterior motive for the termination may have been the result of confrontation between petitioner's principal and respondents. Court of Appeals also found petitioner act of retaining and hiring other equally unqualified teachers who do not possess the required eligibility and allowing them to teach as badges of bad faith. Whether or not the dismissal of the respondents were premature prior to the deadline set by the Professional Regulation Commission for teachers to acquire their license. Yes, the Supreme Court agrees with the decision of labor arbiter, the National Labor Commissions, and the Court of Appeals. It is incumbent upon the court to afford full protection to labor. The law has provided a specific time frame within which respondents could comply. Petitioner has no right to deny them of this privilege accorded to them by law, insofar as Palacio, Calibad, Lacao, Santander, and Monte de Ramo are concerned. Being dismissed on March 2000 was premature. However, Saele's dismissal has legal basis for lack of required qualification. Petitioner intention and desire not to put the student's education and school operation in jeopardy is neither a decisive consideration for respondent's termination prior to the deadline set by law. Petitioner cannot possibly presume that respondents could not comply with the requirements of the law.